the lack of information that kids and adults have about what our rights and responsibilities are, and it isn't in our culture. We're getting there, but we've got a long way to go. And that relates why I wanted to answer with respect to the living tree, is what you're asking is you know, we've got this principle that we've used with respect to the Constitution, the idea that when we're interpreting the Constitution and the Charter, we have to take into account the local current context because things have changed. And I think the last example that you were just given is an excellent example where the interpretation of Section 15 lends itself to some of that living tree. Where I see a weakness with respect to that is, again, as I said, economic, social, and cultural rights. I think that is where people are suffering right now in Canada a lot, and I don't necessarily feel that the Charter can address it, and that the courts have stepped up in their interpretation of Section 7 and 15 to accommodate that, i.e. the Gosling case. With respect to the politicization of the Charter, I kind of think we need to take a step back, and I want to tell you that I feel that the Charter is actually does not have its essence in the UK. It is a unique document. It has a lot of features that are quite different than a Charter of Rights and Freedoms or international rights. It is somewhat similar to the Universal Declaration of Human Rights, indeed, and arguably has incorporated some of those rights. But let me tell you what's unique about it. If you take the Charter and compare it to the U.S. Constitution, for example, they don't have the equivalent of a Section 1 in their Constitution. They do the balancing internally. When they're interpreting freedom of expression, they limit it when they're interpreting the right. Canada is much cleaner because we have a wide recognition of the right and interpretation, right? Maybe not as wide as some people would like, but it's pretty wide. Like, for example, freedom of religion. All we say is it's sincerely held belief. That's what it is. Then we move on to say, is there a reason to limit it under Section 1? That's unique. That step by step is unique. And that, so I don't think that we can honestly say they don't even have a Charter of Rights and Freedoms in the UK. They use the European stuff, and reluctantly. So I think that is unique. The other aspect has already been alluded to as well, is the notwithstanding clause. You don't see that in Charters of Rights in other jurisdictions, nothing like that. That was a compromise that came up as a result of the province's concern about the role of the legislatures and the court in making laws. And I must correct one little that you wouldn't know about because it's an embarrassment. But we actually did invoke the notwithstanding clause in Alberta in 2002. We passed during the spring sitting, a law that said marriage had to be between a man and a woman, and that this operates notwithstanding the Charter of Rights and Freedoms. And because it was in the spring sitting, there wasn't a lot of talk about it. There were a few people who were deeply concerned because it's ultra virus, the province, to pass that law. So never mind the notwithstanding, it had nothing to do with the Charter. They don't get to say who can get married. That's federal jurisdiction. But besides that, because they did it at a time of year when people don't really monitor things that are going on politically, they got away with it. And it's that, it was never challenged. It was challenged a little bit in the legislature in the fall, but by then it was already an amendment to our Marriage Act in Alberta here. So the notwithstanding clause is important. I spent a lot of time thinking about this. At first I didn't like it. I objected to it. I thought, well, what's the point of telling people they have these absolute rights that if the government can say, yeah, you've got these rights, but we're going to take them away. However, what I have seen in practice is that it is balanced because there's such a huge political price, except for in Alberta, to invoking it. Because people react that way. Why are you taking our rights away, government? And so the government is very cautious about except for Quebec, who tried to pass an omnibus, notwithstanding clause, but that's a whole other issue. So I guess my opinion is that I don't think the politicization of it has so much to do with the fact that we brought the Constitution home and then added the charter scheduled to it. I think the charter is quite unique. I think there are other things happening. I argue, in my mind, I think we've got, please forgive me, an Americanization of our system here. And I think you're seeing, this accusation of judicial activism and all these things. To me, that's very American. And I think we need to push back on that and say, we're different here. And we do things differently in this country. And we have different values, and we don't want to. We've always kind of skated down the middle between the US and UK in terms of our legal, political sort of history. And this is a situation where I think we need to stand up and say, we're different from both of you, and that's okay.
Well, my closing comments will be that, first of all, is there a human rights culture in this country? There's certainly a human rights culture within the bubble that Linda and I and our colleagues work. I think that
and it is a bubble.
Yeah. Well, and I think that we need to step out of that bubble. I work with some very broad-minded people, and I count them amongst my dearest friends. And I've got family members who, I love in spite of some of the things they say. I come from rural, white, working class background, and there's some rednecky people in Nova Scotia, believe it or not. So what I've learned, what I think we need to do, work inside the bubble, as I call it, is to recognize that we do work inside a bubble, and we got to step outside the bubble, and instead of, and I'm saying this more for myself because I can sometimes react strongly, negatively when I'm faced with something that's blatantly racist. But now I've learned, talk to people, you can get them to change their perspectives, and sometimes too when somebody says something that's really, really offensive, I've come to realize that, they may be just testing the bounds of your beliefs, and what they need is, dialogue, discussion. I think we need to recognize that there is discussion here. That for me is, you alluded to the living tree constitution doctrine. I'd like to take that and apply that to the kind of work that I do, because I do believe that a democracy, Canadian democracy, is indeed a living tree. We don't believe in a final solution, we don't believe in a final determination, but this way it's going to always be that way. To me, debate and discussion is the hallmark of a democracy. It's what keeps us moving forward. I get really nervous when people talk about, we need to end this once and for all, because anytime a political movement has said we need to have a final solution, or we're going to perfect people, we're going to perfect society, within a generation we've got people in the death camps, all right? So our system is flawed, deeply flawed in the eyes of its critics. You know what, so what? Because I like working with people who are flawed, because I'm a flawed person myself. And I think it's important that we work in a transparent system, and as long as we're talking, we're moving forward. Those are my final comments.
I'd like to thank all our panelists once again for speaking, and thank you to everyone for coming out and sharing your thoughts and your questions. So a big round of applause for everyone.
Happy birthday, Charter.
Happy birthday, Charter.
Happy birthday, Charter.
Hey, Zach.
Thank you, Zach. Thank you.
Thank you, Zach.
It's great to be with you guys. Thank you so much for having me.
Thank you so much for enlightening me on Quebec.
All right.
Well, yeah, if you let me know if you guys ever come to Montreal.
All right.
Sure, we're going to